This is You and the Law on AM 650. Now back to the show.
Welcome back. Good to have you with us this Sunday morning. We're talking with David Hobbs and Ian Girodi from Hobbs Girodi, Vancouver Estate Litigation Lawyers. You can find out lots more about the firm at hobbsgirodi.com. A terrific website. That's lots of good information and nice pictures of you two. And also, I should let you know that if you've been following the program and are relating to some of the issues that we're discussing here, going, I could probably do with a conversation with a lawyer in my life because, geez, this is sounding a little familiar, and I'm not feeling as comfortable as I should be, perhaps, being named in someone's will. That first conversation with you or Ian, David, is not going to cost anybody anything, is it?
No. We always meet with people initially just to determine whether or not we can all work together and to get a preliminary idea of what their problem may be, about whether we can be of any help or not.
Right. Okay. Well, that's good to know. It's comforting to know. I wanted to ask you, we talked a little bit about tax and estate planning. It's not what you do, but what you do is pick up the mess after people who haven't done good estate and tax planning. For example, people, Ian, who try to avoid probate fees and other tax issues by doing what they think might be legal maneuvers, putting their house in joint ownership and that sort of thing. Not always well-executed strategies that really can backfire and end up in your lap at some distant point in the future, right?
Very true, Sterling. Just to give you to use the example of putting real property into a joint tenancy,
okay,
with a right of survivorship, because I do want to emphasize that one can put title to real property in joint ownership that does not have a right of survivorship as well, and create other issues.
So if you're going to go that route,
right,
make sure you step carefully.
Right.
Okay.
So, but let's just assume that the purpose of putting that property into joint tenancy was simply to avoid probate fees,
right,
and it was put into joint tenancy with the named executor, with the understanding that the executor would treat that property as part of the estate when it came to distribution under the will.
Yeah.
If that's not documented, and if the will maker hasn't told all of the beneficiaries, I've made this arrangement with my property, but it's just for the purpose of
it's a little tax
avoiding the probate fee.
Right.
And he's going to distribute. If that's not papered in some fashion, you may have the executor, who is as well could be a son,
mm-hmm,
or
yep,
a daughter,
yep,
or a spouse, who says, no, that was meant as a gift.
Right.
And
in the absence of anything to the contrary.
Right. Now, there's some law about that in terms of what presumption, what you start with, whether it's a gift or whether it's held in trust for the estate, but it's just a presumption. So it's far better to make sure that there's a very good record of the intention in transferring title there. And that's a clear example of the mischief that can arise from that sort of, try and save a few bucks, and it turns into a much greater headache.
David, you look like you want to jump in on this one too.
No, I was just saying it's interesting because, all these discussions we're having ultimately are all about intention. What is a person's intention?
Right.
So if my intention is to not make a gift and to avoid probate fee, then that's my intention, and that's why it's not a gift, because it wasn't what I really intended. And so all these, I'll call them tricky plans, they can backfire because they just simply aren't what they appear to be. And in a case where you're going to say let one child become the owner of the family home through joint tenancy, with an understanding that house is held in trust by that child for all the other children named in the will, as if it was an asset in the will,
right, just
to get away from the probate fee, would have to be well documented, because really what you've done is created a trust, and the whole purpose of avoiding the probate fee probably is questionable as well. But I'm not aware of any situations where people have been challenged, by the people who collect probate fees for these types of transactions, because they're quite common.
Is it the case that in a lot of your court work, you have to try and assume intent in the absence of documentation? I mean, the person that is the will maker has passed on. He's not there or she's not there to say, no, that's not what I meant. And in the absence of that clear documentation, you have to try and imply intent. Is that part of the job for you two?
Well, we use the law uses the word presumption. So the law has some presumptions, and we also use a fancy word called rebut or rebuttable. So there are rebuttable presumptions. So for example, if I make my wife or my infant, and I emphasize the word infant, i.e. under 19 child,
Okay.
the joint tenant of an asset of mine, it's presumed to be a gift. But if they're neither my spouse nor my infant child, i.e. it could be my adult child, it's presumed not to be a gift. And then the person who receives the benefit of this has to rebut the presumption. So the law presumes it's not a gift unless you prove to me that it is.
I see.
And so there are presumptions that come into play in legal disputes.
But Ian, I think as you and David and I spend more time together on you and the law, it becomes clearer to me each time we assemble that as one plans one's life and draws up a will, the more clear you can be about what you want to happen after you die, the more likely it is that that actually will happen. Correct?
Absolutely correct, Sterling. That goes not only in terms of what you say in the will, but also what you do and say outside the will. So if you want to avoid problems with assets that you've put into joint tenancy and therefore at least apparently taken outside of your estate,
right,
you better paper it. You better paper it well, and you better let the interested parties know about that. Similarly, if you prepare a will where you're treating different of your children more favorably and less favorably,
yes.
you better document why, because the Wills Variation Act allows the court to take into account your written reasons for why you have left a much more substantial gift to one child, or as opposed to one or more, or vice versa. And it could be something like simply because I've given so much to that child that I've treated less favorably during my lifetime.
Right.
Or it might be the person is addicted to drugs and alcohol, and he or she will dissipate whatever I give to him, and etc.
Whatever the reason, identify it and be very clear. Spell it out in language that, well, Hobbs Girotti may not have much difficulty sorting out, let alone the probate courts. Ian and David, thank you so much. Good to see you again. Already at the end of another episode of You and the Law. I look forward to our next gathering. And we'll see you next time here on AM 650.